Please be seated.
Thank you. At this time we're on record in Regan versus Denney. Matters before the court for oral argument. On behalf of the appellant, Regan, Brian Smith will argue. On behalf of respondent, Lawrence Denney, Brian Kane will argue. William Zanzig will appear only. On behalf of the intervener respondents, Belzer, etc., Kenneth McClure will argue. Jeff Bauer will appear only. Are there any preliminary matters? None? You may proceed, sir.
Chief Justice Burdick and distinguished justices, I bring you greetings from Southeast Idaho. This case with I see that. Finally we have one from Southeast Idaho. This case we have brought before you today is about Idaho's fundamental lawmaking authority under Article 3, Section 1 of the Idaho Constitution. This case is about whether that lawmaking authority is a power to act or a power to be acted upon. In other words, we submit that Article 3, Section 1 empowers an Idaho lawmaking body to chart a course for Idaho through affirmative, deliberate, and positive action. Article 3, Section 1 does not permit lawmaking power to be exercised by another authority or body to make the law in Idaho that we then must react to. That's why we say we can either act in this state or we can be acted upon. Now, this case has been fully briefed, but last week, respondents sent this court updated authorities, identifying a rule of statutory construction that respondent did not raise in any of the prior briefing. I want to address this new law. It's not actually new law, it's a new reference to law that we have yet to be able to address with this court because this is our first and only chance to address those new authorities. They have cited the law that where one statute adopts the particular provisions of another by a specific and descriptive reference to the statute or provisions adopted, the effect is as though the statute or provision adopted had been incorporated in the adopting statute. Such adoption takes the statute as it exists at the time of adoption and does not include subsequent additions or modifications of the statute so taken unless it does so by express intent. Respondent today will no doubt argue that the specific federal code provisions referenced in Section 56-267 satisfy this requirement, meaning that respondent will argue that this rule of statutory construction ends the discussion because its application prevents incorporation into Section 56-267 of any future changes the federal government might make for Medicaid expansion eligibility. But the respondent knows full well this is not the case entirely. The best way for us to show this to the court is to review the federal funding on Medicaid expansion, which is a part of Section 56-267. This issue came up in our initial brief. They did not address it, and we did not reply to it. It did not come up again squarely until the respondent cited additional authorities. As this court knows, in an initiative process, the Attorney General will review the initial petition. Section 4 of the initiative petition used to say this, and it never made it into the final law. Quote, "This act shall become null, void, and of no force or effect as of the date that federal financial participation for low-income adults is reduced below the 90% commitment described in, very specific, 42 U.S.C. Section 1396DY. That's a very specific reference to the provision that provides a 90% reimbursement. When the Attorney General reviewed the initiative petition, they talked about this section, and what the Attorney General said was, the sunset clause set forth in Section 4 of the proposed initiative presents a unique issue. And I would submit that that's why this is a unique case. The operation of the Medicaid program is governed by an approved state plan, and until the program could get an amendment approved by CMS or the federal government, the program would be required to continue providing services resulting from Section 1 of the initiative, even if the sunset clause in Section 4 was triggered. That's a remarkable observation by the Attorney General. The Attorney General is admitting that even if the federal government changes the law, that the state would still be required to provide services. And he continued, there is a possibility that the amendment to remove this service could be delayed or even denied. It's the passive voice. What he's really saying is there's a possibility that the federal government may not immediately let you out. If CMS outright denies the proposed amendment to return to the current eligibility criteria, the Medicaid program would have the opportunity to challenge that, both administratively and, if necessary, through the courts. However, the program would be required to continue providing those services with a higher percentage of state funds until a decision could be obtained. The time that the state would have to continue providing services could be anywhere from a few months to several years. What the Attorney General recognized when he reviewed the initial initiative petition was that the federal government could, in fact, change the funding requirements for Idaho. And even if Idaho objected, Idaho would be stuck with those funding requirements and also providing services, even though Idaho hadn't agreed to those funding requirements, and it could be for several years. The Attorney General also said until a final decision could be obtained. Now, he kind of left that kind of nebulous hanging out there, but what he's really saying is we don't know what that would be.
Well, Mr. Smith, those concerns, I think, were expressed before the rule of construction from the Nampa Meridian irrigation case that I think you were somewhat referencing earlier in your argument were brought before this court. Does the holding in that case, and it's not a new case, it's a 1924 case, almost 100 years old, does the holding in that case point us in a different direction then, and why not if that's not the case?
So you'll notice when the Attorney General reviewed the initiative petition, he didn't say, oh, don't worry about this. We've got rules of statutory construction that protects Idaho's Article 3, Section 1 authority. He didn't say that at all.
But we're not bound, and neither is the Attorney General's office, by a preliminary opinion that they made about an initiative that hadn't been passed yet. There's no judicial estoppel in play here, is there?
So this rule that I just mentioned that they've raised in their subsequent authority says where one statute adopts the particular provisions of another by a specific and descriptive reference. The question is, when it comes to funding for Medicaid, where is the statute that adopts the federal provision, and is it specific and is it descriptive? This is why when I read what the Sunset Clause said, the Sunset Clause was descriptive and it was specific. It identified 42 USC Section 1396 DY. That is the exact provision that identifies how much the federal government would pay. Idaho statute The Idaho statute that references federal law on the Medicaid payment, it's very complicated. I think I'm right, but I think it is Idaho Code 56-252, subsection 9. And here's what it says. Medical assistance means payments for part or all of the cost of services funded by Titles 19 or 21 of the Federal Social Security Act. That doesn't sound to me to be very specific, not like the Sunset Clause was in the initial initiative petition. In fact, it says Titles 19 or 21. Which one is it? Is it 19 or is it 21? And so the reason that that rule that they've cited, although it may apply to the eligibility requirements because that has very specific provisions, when it comes to the funding, there was a specific provision. It was in the initiative petition initially. That was removed. They took it out. And what we're left with now is a reference to Titles 19 or 21 of the Federal Social Security Act, and we don't know which ones those are that would specifically apply. So our position is that when it comes to the funding requirement, there is not a particular provision that gives a specific designation. So that rule would not apply to the Medicaid funding.
So one of the issues that I have with the Attorney General's opinion is that particular section actually doesn't address the nuts and bolts, if you will, of the plan requirements. So I looked at the regulations on state plans, and it's 80 pages worth of federal language. And one of the things that I'm unclear about is exactly, I'm basically asking the question, is the Attorney General's opinion correct in that regard? And one of the problems, it seems to me, that we have in this case is the Department of Health and Welfare has not been invited to this party and isn't here in the courtroom today to talk to us about what the particulars of the Medicaid regulations really mean and how accurate is the Attorney General's position on plan requirements.
Yeah, and that's a multi-headed question, I'm sorry. Is there one part of that specifically you'd like me to reference or respond to?
Well, let's address the fact that the Department of Health and Welfare isn't a party here today, and to what extent, and this is maybe a topic that's often overlooked, but to what extent the court could even fashion a remedy to prohibit the enforcement of this act where the Department of Health and Welfare isn't here.
So the court did allow the interveners, and part of their plea to enter the case was the expertise they could bring to this about explaining how the Department of Health and Welfare works. Technically, we don't really need the Department of Health and Welfare in order to seek the relief that we've asked for. We've asked for a determination that this provision is unconstitutional, and also for essentially we asked for a writ, not knowing whether it would be a writ of mandamus or writ of prohibition. That would be directed toward the Secretary of State. And
why would a writ against the Secretary of State, whether it be a writ of mandamus saying don't codify the law, or a writ of prohibition or writ of mandamus saying do codify the law, how does that help us in the sense that this court has ruled since 1960 that the codification of the law is not the law? I mean, it's evidence of the law, but that's it.
Well, certainly, if this court declares that the statute is unconstitutional, people are going to understand that and follow that and know that. And then all we're asking for, in terms of a extraordinary writ, is that it be removed from the books. But I assure this court, if this court were to determine that this statute's unconstitutional, I seriously doubt that the Department of Health and Welfare would move forward with its plan. I just don't see that being an issue. I mean, we could have named them as a defendant, but I don't think it's strictly necessary in order for this court to achieve a ruling on whether the statute's constitutional or not.
So, Mr. Smith, I had a different inquiry when I was looking at the briefing, and one of the things I tried to do was understand what the percentage of the federal poverty limit is for the people in Idaho who are currently receiving Medicaid benefits, and as near as I can tell, and this is a rough approximation, it's about 21% of the federal poverty level that enables Idahoans to access Medicaid who are under 65 currently. And so the statute that you're attacking, 56-267, raises that level to 133% of the federal poverty level. And one of the things I'm trying to understand is, if the legislature had done this, would you have a quarrel with it? And because the people did it, why do you have a quarrel with it? It seems to me that the people of the state have simply said, we're going to raise the level from 21% of the federal poverty level to 133%, and that strikes me as a fairly innocuous legislative action, whether it's done by the legislature or whether it's done by the people. And I'm trying to understand, why do you think that that somehow has given the federal government the control over how we determine who's eligible for Medicaid?
I appreciate the question. The reason it's not whether the people adopt that or whether the legislature adopts that. The question is how is that federal poverty level arrived at? It's arrived at by, this is how I understand it, and I'm no expert on the federal poverty level, but as I understand it, it's arrived at from a compilation of data from 48 contiguous states. I'm not sure that Alaska and Hawaii are even applicable. And so what happens is that Idaho, then the poverty level is, federal poverty level is set by data they get from New York and data they get from Florida and California.
It's the District of Columbia. And
District of Columbia, which we know is the most expensive place to live. The point is, it's not just from Idaho. So here, the federal poverty level, Idaho has adopted a standard that the federal government can change based on federal standards with very minimal input from Idaho. In fact, probably, I'm just going to speculate, maybe 95, 98% of that level is set by factors that have nothing to do with our state.
But if that's the case, and my math is correct, it's currently about 21%. And haven't we already ceded that responsibility to the federal government? And aren't you suggesting then that Medicaid in its current iteration would be unconstitutional?
What I am suggesting is nobody's raised this issue to this court before.
But aren't you suggesting that by your argument that it's unconstitutional to raise the level from 21% to 133%?
What I'm saying is that without a codification by a lawmaking authority under Section 3, Article 1 of our own Constitution, by adopting another law, we've unconstitutionally delegated that authority. So I'm not sure how, I'm not sure if Idaho has adopted the federal poverty level through a legislative process or through lawmaking authority. But if they do it as codified, and this is one of the arguments we make from Justice Bake's dissent in the Kellogg case. If Idaho says, look, we adopt the federal poverty level as it exists today, now we're exercising our own Article 3, Section 1 lawmaking authority. But if we just say we adopt the federal poverty level, then that allows the federal government to make changes and we cede our sovereignty and we lose a portion of our lawmaking authority under Article 3, Section 1.
Mr. Smith, if we were to accept your argument as the correct statement of the law, then what does that mean for other Idaho statutes that are tied to a federal standard? In particular, I'm thinking of Idaho Code 44-1502 that deals with the minimum wage. That statute says the amount of the minimum wage shall conform to and track with the federal minimum wage. If we adopt the standard you're arguing for today, what will that do to other similar laws in this state that are based on a federal guideline or standard?
Part of it depends on this new authority that they've raised. So if there's a specific reference to federal law that falls within this, this rule that they've identified, it's, I think they said it had to be specific and descriptive, then there is this argument, rule of statutory construction that would say, okay, we can do that, and if they make changes, then those changes aren't adopted or amended into the existing statute. But that's not the case here when it comes to the funding of this Medicaid expansion. As I've explained, all they reference is the Social Security Act, Title 19 or Title 21. And so for the rest of those, we'd have to look at them on a case-by-case basis. If in fact, you know, what we're really talking about too is telling our legislature that they've got to do their job better. What we need to have them do is be specific. They need to tell us which code sections apply.
But this wasn't the legislature, was it? It was the people. And unlike the legislature, whose power to pass laws is delegated in Article 3, Section 1 of our Constitution, the power to pass laws through initiative is a reserve power. I believe the provision says the people have reserved the right to themselves to pass initiatives. Since this was done through a reserve power of the people, should we look at it any differently?
I would tell the court that we have given the case law that says that whether it's initiative or a referendum or whether it's passed by the legislature or signed by the governor, it's all on same and equal footing. But I would say this. When the people voted for 56, well, we'll say Proposition 2, when they voted for that, they also understood that the federal government was going to pay 90%. That's what they understood. Now, the federal government could change that. If they change that, then the people just voted for something that becomes different from what the law would become in the state, according to the Attorney General, and it might be different for years. The people didn't vote for that. And that's why it's important that we apply the same constitutional constraints to an initiative process that we do to legislation passed by the House and the Senate, signed by the governor. It's all within Article 3, Section 1 lawmaking authority.
Anytime a state agency or the legislature has a benchmark, the Uniform Price Index, right, is that does that fall under the same argument that you're putting here today, that pension funds or other prices that are hinged to the Uniform Price Index, every time a benchmark is adopted by the legislature or by a state agency under their rulemaking authority and passed by the legislature, does this then apply also?
All they would have to do is say, we adopt it as codified, or we adopt it as currently amended. This is a matter of great importance.
Does it apply to every benchmark that is used in state government?
It would apply to any law that would allow another body or another authority to make law that would apply to our state.
So it would mean basically anytime you've got that federal benchmark being used as a standard, the legislature is going to be required, like it does every year for the tax code, the adoption of the tax code, it's going to have to specifically take affirmative action to adopt the current version of the federal law.
That is a great point, because why does the legislature do it for the tax code, but it doesn't do it for other things? And I can't answer that question, except perhaps it could be that Attorney Lance opinion that came out several years ago, and they do it. But I know that's one of the first things they do every year in January is they do, I think they call it a conformity bill. They need to conform. Well, either we conform or we don't. And so that's one of the issues we've raised in the case. I'm totally lost now on my clock, so I don't know how much time I have left. So I'd like to, unless you have any other questions, can I reserve the balance of my time? Thank you.
Mr. Chief Justice, members of the court, good morning. May it please the court, Brian Kane on behalf of the Secretary of State. With the permission of the court, respondent and interveners have agreed to split our time with 20 minutes to respondent and 10 minutes to interveners. Petitioner has filed a petition for review that is without foundation both procedurally and substantively. I would like to first address the procedural and jurisdictional deficiencies and then address the merits arguments. This proceeding was filed as a petition for review with a single jurisdictional statement on page 3, numbered paragraph 1 in the petition for review. Jurisdiction is appropriate under Idaho Code Section 34-1809-4. Petitioner affirmed this statement within his opening brief on page 6, wherein he specifically requested that this court proceed under Idaho Code Section 34-1809-4 and not Idaho Appellate Rule 5D. As of this date, this office cannot advance any argument in favor of the constitutionality of Idaho Code Section 34-1809 sub 4. This court has unequivocally stated that the original jurisdiction of the Idaho Supreme Court is fixed by the Idaho Constitution and not by statute. The court has previously indicated its doubts as to the constitutionality of 34-1809-4 in Ney versus Santa Rosa, and more directly in its order dismissing Bell versus Santa Rosa. No defense of constitutionality of 34-1809 has been advanced by petitioner. Petitioner has not voluntarily dismissed his petition, nor has he amended his petition with regard to this jurisdictional issue. Instead, petitioner now claims that this is a petition for a writ of mandamus, but demonstrates no legal basis for mandamus. In order to demonstrate that mandamus lies, petitioner has to demonstrate three things: a clear legal duty to act, a ministerial or executive act to be taken, and no other plain, speedy, and adequate remedy at law. In this case, petitioner asks this court to order the physical removal of a validly enacted statute from the books. In essence, petitioner is asking this court to order the Secretary of State to repeal Idaho Code Section 56-267. There is no clear legal duty for the Secretary to remove a statute from the code. This is not a ministerial or executive act. Repeal of a statute is a legislative function defined under Article 3, Section 1.
Even if we conclude it's unconstitutional?
Yes. Generally what happens when a statute is declared unconstitutional, an annotation is placed into the code indicating that the statute is unconstitutional. Idaho statutes, there are numerous examples of Idaho statutes that have been declared unconstitutional, and there's an annotation under them that will indicate this is the provision of the code that's unconstitutional.
But it remains on the books.
It remains on the books, absolutely. And we actually, we have constitutional provisions that this court has declared as unconstitutional. They remain on the books with an annotation underneath it indicating that it has been declared unconstitutional. Petitioner cites to Idaho Code Section 73-205, which is provision with regard to the Code Commission. That's at page 7 on their reply brief.
Did we not say in Denney that given unique and compelling circumstances, we will get to the issue of constitutionality? And as such, we have a legislature that is waiting to see what happens in this decision, up or down. And is that not unique and compelling for us to reach the final issue in this case, whether or not this is constitutional?
That clearly is within, that determination is clearly within the province of this court. But I respectfully would submit to this court that this case does not rise to that level.
If we follow your argument and dismiss this on procedural grounds, then the legislature is left with, is this good law or bad law? What are we going to do? So they're paralyzed, and then the people's will is also paralyzed. Or we file another lawsuit, it takes a couple years to get here. Is that not unique and compelling circumstances?
Mr. Chief Justice, you raise a strong argument for why this case, for why the merits probably should be reached within this case. But I also think, I mean, constitutional challenges to statutes arise all the time. And, you know, part of the flaw of this case is that the petitioner is seeking to arrest the implementation of a statute by suing someone that has nothing to do with the statute. Well, this is a case, I mean, I don't want to downplay the significance of this case, but in terms of legal procedure, this is a very routine declaratory judgment, temporary restraining order injunction case against the director of the Department of Health and Welfare. This kind of case, in my estimation, is filed all the time. But I also recognize the posture of it, that the statute itself carries with it a 90-day deadline. The legislature is looking at it because there's a funding mechanism. And so if the court reaches the merits in this case and clarifies it, I think that that's well within the bounds of the court and very helpful to the state of Idaho and the legislature.
Well, Mr. Kane, before we inevitably get to the minutes, let me ask you a question about the constitutional challenge you're raising to Idaho Code 34-1809. Let's assume for a second this court agrees with you and finds that statute unconstitutional. Is there any relief for a party who relies in good faith but to his detriment on laws that are passed by our legislature? And let me rephrase that in a more legal way. When a statute grants a substantive right, i.e. the right to petition the government for redress, and that statute is declared unconstitutional, should we consider that statute void ab initio, or should we only consider it void in the future?
Mr. Justice, to me, I think it goes to the nature of the statute. And when I look at 34-1809 sub 4, It's clearly a legislative enactment attempting to fix original jurisdiction within the court. And so, in my estimation, an attorney is required to have made a reasonable inquiry into the law prior to bringing their suit. And in my estimation, part of that reasonable inquiry is to identify the fact that that is jurisdiction fixed by the legislature, which is prohibited by the Constitution. And so therefore, you have to look then to Article 5, Section 9 to determine if there is original jurisdiction. And I think that when I look at this lawsuit, petitioner has tried to do essentially all of those things, although it's somewhat inartful, because it's captioned a petition for review. Well, a petition for review is somewhat synonymous with a writ of certiorari under Article 5, Section 9. And so there is a thread to get into this court's original jurisdiction under Article 5, Section 9. When you look at the constitutionality of 34-1809 sub 4, I don't think that there's a defense that can be advanced to that. But I also think that when you look at Article 5, Section 9 and think about this as a petition or a petition for review, what exactly is being reviewed? Because generally a petition for review includes some sort of underlying decision. And a good example of that within the initiative context is found within the Attorney General's preparation of ballot titles. The Attorney General is not acting as adversary or proponent. He's functioning in an objective, quasi-judicial fashion to object objective ballot titles. That then comes to the court originally to review whether those ballot titles are in fact objective. And so I think that's a good example of how you get to that original jurisdiction.
I think your analysis of the jurisdiction issue and the standing issue is strong, but it doesn't change the fact that the reason why petitioner is here before this court is because our legislature told him to file this before this court. Is there not any consideration or issues of fairness that should affect the court's analysis of the issue under those circumstances?
Mr. Justice, to me, that's something that's within the discretion of the court. My read of 34-1809 sub 4 and the case law interpreting it, as well as the previous orders regarding it, it seems fairly clear. But I also recognize the discretion of the court. There are issues of fairness for why you may want to get there.
So I'd like the Secretary of State to address the argument that this court cannot, or that the state cannot apply the rule of statutory construction enunciated in the Nampa Irrigation District case because of the way that the state plan functions, that it takes us outside that rule.
Could you ask that question again, please?
It's
the merits?
The
merits
of the case. I want to
Okay.
know why,
Yes. Okay.
why can we apply the rule of statutory construction that you're advocating?
Yes. Substantively, petitioner's legal theories are equally without foundation. First of all, petitioner fails to read the plain language of Idaho Code Section 56-267. And importantly, within the argument he just presented to this court, there were no references or discussion of Idaho Code Section 56-267. And yet, when you think about it in terms of delegation, under Kellogg, the court, quoting American Power and Light, recognized that there are 3 requirements to a valid delegation of authority. You have to delineate the policy. What is the policy that we want to implement? Here, it's Medicaid expansion. Number 2, what is the public agency to apply that policy? Here it is the director of the Department of Health and Welfare. And then the third criteria is what are the boundaries of that authority? And this initiative, I doubt it could be more specific with regard to the boundaries. You have to be an individual under 65. You have to have a modified adjusted gross income below 133% of the poverty level and otherwise not be eligible for coverage. That's very specific. That's well-bounded authority. There is no delegation to the federal government within that. There's simply a reference.
Let's take a look at the statute. It references, for sure, the federal statute that sets those same parameters, but it also references a code provision that deals with, a code provision that deals with adjusted gross income and how adjusted gross income is calculated. Can't the federal government change how adjusted gross income is calculated? And there's nothing in 56-267 that addresses how adjusted gross income is calculated at all.
That is correct. And I think that that's where that rule of statutory construction that the Secretary augmented to the court with comes into play. And I think that when you look at that authority, you've got that authority in both the Nampa Meridian Irrigation District case, the Brannon case from 2012, but then if you closely read the Attorney General's opinion from 1989, that opinion addresses a statute that said, as here enacted and hereafter enacted. The Attorney General reviewed...
But the petitioner argues you can't apply that rule, court. The Department of Health and Welfare cannot apply that rule. There's a plan that gets filed with the federal government that creates a situation where the state must abide by the change in the law.
Well, with all due respect to petitioner's position on that, the state has changed and resisted several times. I mean, when the Affordable Care Act was first enacted, the Affordable Care Act was enacted as a mandatory requirement upon the states. The state of Idaho, along with 26 of our sister states, sued under NFIB versus Sibelius to say that is a breach of the Constitution spending clause. You can't force states to make that change. And so the state of Idaho has consistently approached any change within Medicaid as requiring the state to opt in. Now, you're right. Once the state opts in, the state complies with the regulation. But the initial decision for the state to opt in is made by the state. And we have repeatedly, as the state, fought to protect and preserve that right, because we did it in NFIB versus Sibelius. We did it again in Armstrong. The Attorney General's opinion from 1989 clearly states that if there is a change to this statute, the legislature must act to implement this change in the statute. And the 1989 opinion dealt with the Medicaid. And that's where they referenced that rule of construction and said, if you reference a statute, the default rule for reference is how that statute reads at that point in time when you adopt it. And if you want an example of an incorporation by reference, because I don't think that this statute rises to the level of actually incorporating, a good example of an incorporation by reference is actually in 63-24-34. And in that statute, it says in the lines of the statute, incorporated by reference herein as though set out verbatim. And so when the legislature wants to incorporate by reference, it knows how to do it. Additionally, if you look at within our brief, we've cited to a few examples of statutes that actually incorporate future amendments. And so again, when the legislature wants to do that, they expressly set forth that within the statute.
Does that undercut your argument, though, that we ought to look to Attorney General Lance's opinion for guidance here? I mean, because you're saying this is not an incorporation by reference statute, and I understood that opinion was built around that notion.
So just to clarify, the 1989 opinion was by Attorney General Jim Jones.
Oh, excuse me.
The petitioner has referenced the 95 Attorney General Lance opinion, which references the tax conformity statutes. What I'm saying is that petitioner has advanced a number of theories. And if you start with the plain language, there's no delegation within the plain language of the statute to the federal government. It simply references a statute. If you take the next step as a court and you say, well, I'm not altogether buying the Secretary's argument that there's no incorporation. Well, if you go the next step and say, oh, there is incorporation, well, okay, but that still doesn't get you to where petitioner wants the court to go. Because even if you incorporate, it's incorporated at that specific point in time. And the real key here is that petitioner has not raised a single issue with foundation. Based on the plain reading of Idaho Code Section 56-267, there is simply no delegation to the federal government. This petition is without legal foundation because no cogent legal theory has been advanced procedurally or substantively in the course of these proceedings as demonstrated by briefing and argument. The Secretary of State respectfully asks for his reasonable attorney's fees as provided for within his briefing. Thank you.
Mr. Chief Justice, members of the court, may it please the court, I'm Ken McClure here today on behalf of Interveners, the Idaho Medical Association, Dr. Bruce Belzer, and most importantly, two Medicaid recipients or people who would like to receive Medicaid under Proposition 2, Mrs. Delina Foster and Mrs. Pamela Blessinger. Neither of those two can be here today because they are doing what most Medicaid patients are doing, or most people below the federal poverty level are doing. One of them is working, the other is taking care of 3 preschool children in Pocatello, and neither can be here. I'd like to first of all explain for the briefing, as we briefed in our materials, the definition of the gap. When the Affordable Care Act was enacted, it didn't have a Medicaid gap. The Medicaid gap is the result of the court's decision in FIB versus Sebelius. As originally conceived, the Affordable Care Act provided health care benefits to people below 400% of the federal poverty level. They did that through both expansion of Medicaid and through provision of subsidies and tax incentives for the purchase of private insurance. The decision in Sebelius created the gap and the very unfortunate and awkward result of allowing government support for provision of health care to people who have more than 100% of the poverty level, but not allowing any support at all to those who need it most below 100% of the poverty level. To respond to your question, Justice Stegner, yes, at the very, very lowest of levels, there is Medicaid support. But between those levels and 100%, there is no support for any kind of health care for those who are in that position. It creates the odd result of having virtually no place to go. That is why the people enacted the Proposition 2 to accept the optional Medicaid program, which was not originally designed to be optional, but became optional as a result of the court's Sebelius decision. I'd like to support the Attorney General's arguments on the process, and we have briefed the procedures adequately. I'd like to focus the remainder of my time on the delegation argument the petitioner has raised. That delegation argument has to be dealt with a careful understanding of Idaho Code Section 56-267, that is Proposition 2. Proposition 2 directs subsection 1 of Proposition 2, 267 subsection 1, directs the state to expand Medicaid eligibility to those who are under 65 years of age, who make less than 133% of the FPL, and who are not otherwise eligible for health care. In order to qualify for federal matching funds, this is to be accomplished in accordance with 2 specific federal statutes, not 2 titles of the U.S. Code, 2 specific federal statutes. Subsection 2 of Idaho Code Section 56-267 instructs the Department of Health and Welfare to implement subsection 1 by submitting a state plan amendment to be accomplished in 2 ways. It must first describe the optional benefits that the state wishes to have, and 2, prove that having those benefits And the administration of those benefits will be done in accordance with federal law because that is what is required in order to gain the federal matching funds.
Just like highway matching funds.
Yes, Your Honor. The federal government, as has been recognized by this court in ample precedent, has offered to the states a cooperative program for the provision of health care to the lower income residents of those states. In a cooperative program, Idaho has said, we'll agree to do this. We will operate it according to your rules, and we will provide this care to these people. We will pay for some of it, and if we comply with your rules, the federal government will pay for some of it. The federal government said, deal. That's how this works. That's how a joint program, a cooperative program, operates, just like the federal highway funds, Your Honor. You're absolutely correct. And any number of other cooperative federalism programs the state and federal government have. It doesn't even begin to scratch the surface to say that there are just the Medicaid funds and the highway transportation funds. We have all sorts of cooperative programs that run throughout state government.
Mr. McClure, by dealing with the delegation argument, are you suggesting that we should reach the merits of this case as opposed to dismiss it on procedural grounds?
Your Honor, in our briefing, we have suggested that the procedural infirmities are such that it should be dismissed on procedural grounds. However, recognizing the court does have the jurisdiction to issue a writ in appropriate circumstances when it has been properly requested. If the court determines that a writ has been properly requested, notwithstanding the way that the petition was actually filed.
Well, in the Coeur d'Alene Tribe versus Denney case, we said that if there were an urgent need, we might reach the merits, notwithstanding the objection to the plaintiff not having actual standing. So is that what you'd like us to do?
Thank you, Your Honor. I appreciate that interpretation of the Coeur d'Alene Tribe case because I've had arguments with counsel about the actual holding in that case, and that has been my position on the holding in that case, which says in matters of extreme urgency, standing is unimportant. I don't know, as I stand here, whether you will find this to be one of those matters of extreme urgency. I don't know that it is. I frankly believe it is probably not, but you can disagree.
People awaiting this decision who would be actually impacted, including the two interveners that you represent?
Your Honor, I think I would answer that this way. By February February 18, the state plan amendment will have been submitted, and the federal government will be looking at the demonstration of compliance and ascertaining that we have already complied with federal law. I don't see that this court can give any comfort to those people other than the fact of allowing the statute to go into effect. That is what my two clients who are hoping to receive Medicaid benefits once it is implemented, that is what they can look to for their assurance. I can understand how those who disagree with the provision's constitutionality want to interrupt its implementation. But this section of law is essentially self-executing, and the urgency isn't there. If you look at Coeur d'Alene Tribes versus Denney, the question was, do we have a law or not? In this case, the question is, we have a law, is it constitutional? And whether that is something that rises in your view, your collective view, as a matter of urgent constitutional need is something I can't forecast. That is why I'm addressing the merits of this claim.
So turning to your client's expertise, do you have any analysis of whether the Attorney General's opinion on Section 4 of Proposition 2 that was not included on the ballot, as to whether it's right about the effect of the plan?
I believe it's not right, frankly, as to the effect of the plan. And I think that you can go to the four corners of the statute and determine that. It's hard for me to understand that there is any delegation at all within that section of code. The section of code is actually quite specific, and it directs the department to submit a state plan amendment that complies with two particular sections of federal law. The first section is that section which is the optional coverage that was made optional by Sebelius, I might add, to people who are under 65 years of age, under 133% of the federal poverty level, and are not otherwise eligible for Medicaid benefits. The other section of the plan is to be presented as a means to document the state's compliance with the laws governing calculation of income and eligibility otherwise for Medicaid benefits.
Say that again. What's the effect of the portion of the statute dealing with adjusted gross income?
The section that deals with, section 1902E14, which is the second specific statute referenced in 267, indicates how the Medicaid program will ascertain which people are eligible for the benefits, and how we will calculate income, how we will have asset testing or no asset testing, how we will allow for expenses or disregards of income, mere guidelines, rules of the road, if you will, for eligibility determination. That is to be done according to 267, just like it is done for all other Medicaid eligibility. These are the rules of the road.
So, Mr. McClure, since you just used the word according to, the statute obviously reads in accordance with. Mr. Smith has suggested in his reply brief at page 24 that if the language said as currently codified, that would be acceptable. Do you see a functional distinction between in accordance with and as currently codified?
Your Honor, it might have said it's currently codified. Is it deficient because it doesn't? No, I don't believe it does. The state plan amendment is to be submitted in 2 weeks, 2.5 weeks, 3 weeks from yesterday, if I'm correct. And this will all be done because the section of the code that we're dealing with, 267 subsection 2, says submit a state plan that conforms to the federal requirements, and submit it by 90 days following the effective date of the act. If I may, Your Honors, the delegation to the executive branch is equally uncompelling or non-compelling. It's simply to fill out forms and simply to demonstrate compliance with federal law. Thank you.
How much time does the appellant have? Sir?
Let me just address briefly some of this procedural issue. I'm a practitioner. I practice law in the trenches. I open up the code book, and Idaho Code 1834094 says, in the initiative process, any qualified elector can challenge directly to this court a constitutional challenge, and it can be reviewed by this court. That's why I call it.
Say that it's a constitutional challenge of an initiative?
It did say of an initiative, and that's exactly what we challenged. The heading got changed because it became a law, but we did challenge the initiative. We didn't challenge a law made by a referendum. We didn't challenge a law made by the legislature.
But aren't you too late if it's specifically directed to an initiative?
Yeah, that's the argument they raised.
Isn't that what the statute says?
Well, what the statute says is an initiative, and clearly the intent of the legislature is that a qualified elector should be able to bring their grievance before this court on a constitutional issue. But the court in no said you can't do that until it becomes a law because it's not ripe. It didn't become a law until the lieutenant governor signed it. And so that's why I said in the brief, we're stuck between the hammer and the anvil. If we follow this court's decision in no, then you've got this semantic argument that you can't comply with 183409. And so we think what the court ought to do is look at the intent of the legislature. They clearly wanted this court to be able to review an initiative that a qualified elector believed was unconstitutional. That's what we did. We relied on that statute. I've been criticized because I didn't know about the court's order many, many years ago. I would tell the court that's not precedent. I couldn't find it in Westlaw. It's not in a published opinion. So there is no law in the state that says that 183409-4 is unconstitutional to the extent of the jurisdictional issue. Maybe that comes out of this case, maybe it doesn't, but the way it stands now, that's not the law in Idaho.
Well, Mr. Smith, let me ask you the same question that I asked from the Attorney General's office, and the statute is 34-1809.
Okay, I got it backwards.
On 34-1809, if the court were to agree that it's an unconstitutional delegation of authority by the legislature that creates standing in the court, and only the Constitution can do that, then what is the recourse then? Is the statute deemed ab initio void, or does it take effect after we make such a ruling?
Well, first there's a provision that it's severable. We've already pointed that out in our briefing. And to be honest with you, I don't know the answer to that question. I haven't looked at that, I haven't briefed it. What I can tell the court is this court's been clear that on important constitutional questions of an urgent nature, this court can accept jurisdiction. I would tell the court that I don't need to get into. I think Justice Burdick made my argument pretty clear. This is a case that falls into those parameters, and so the court still could rule on this. But in terms of us as practitioners, I relied on what the legislature told my client what we could do, and that's what we did. And so people can make fun of it that we call it a petition for review, but that's the exact language from the statute, a review before this court, so that's what we called it. I would also tell the court that the statute itself doesn't require extraordinary relief. It just says the court can rule on the constitutionality. The issues that got raised, first of all, I want to tell the court what didn't get addressed. Respondent did not address this issue about the funding for Medicaid. They were the ones that raised the issue about this new statute or this law that they've cited. I pointed it out that the Idaho law that references Title 19 and 21, they didn't address that at all in the oral argument. Instead,
if I understand it, your argument is that can change at any time by the federal government, then it would take months and or years for Idaho's request to be passed by the federal government.
That's part of it. So what I'm saying is
what I'm also saying then is your case here today premature? Because we know what that benchmark is at this point in time. It hasn't changed, and therefore it is speculation as to what will happen in the future, whether it goes up, down, or stays the same for decades. And as such, is that argument not premature?
Okay, and those are great questions. So on the first part of the question, what we're saying is that an argument could be made that under 56-267, that code section is, to use the language of the Nampa case, it's specific and direct. I can't remember the exact language. I get that. But on the funding requirement, they can't make that argument to say that that rule that they've identified from the Nampa case applies to the funding provision because it's not specific. What was specific was what was in the sunset clause, but it's not specific as it's referenced in Idaho law. So therefore, they can't use the rule of statutory construction to save that part of the statute. With respect to the other question you asked, and that was specifically, is this premature? That's a good question. And the answer is no, it's not premature, because the issue isn't, what could the federal government change it to? That's not the issue. The issue is, can they do it? Because if they can do it, then we're stuck with it, and that means that there's been a unconstitutional delegation of authority. And that was kind of what happened in the road.
You cannot back out of a Medicaid plan? If the government changes something, can the state not say, fine, we opt out?
Sure, but that becomes how I started this argument today. Under Article 3, Section 1, are we going to exercise authority affirmatively? Are we going to act? Or are we going to be acted upon? My point there is that had we kept in the initiative the sunset clause, we would be trying to stake out a fence around the federal government. We'd be trying to preserve our United States Constitution Article 10 authority. We'd be trying to protect our Article 3, Section 1 authority under the state constitution, but we didn't. It's a surrender, it's a capitulation. We didn't even try.
Well, you say that, but we can opt out at any time, can we not?
That's also not necessarily true. We don't know. For example, well,
If we opt in, can we not opt out?
well, so this is why we may not be able to opt out of Medicaid expansion. The Sebelius case addressed the issue of what happens when the federal government puts a gun to your head and makes you adopt a new program. But in this case, once you opt into Medicaid expansion, can you opt out of Medicaid expansion, or are you required to opt out of the entire Medicaid program? So to answer your question, I don't know if you can, and this is the problem. We are now left with unknowable and uncertain changes the federal government can make, and we don't know, and that requires us to play defense instead of offense. I would just also say this. There's been argument today that there's been no delegation, that the language doesn't incorporate federal law. That is a completely different position than what the respondent took in the opposition brief. The respondent in the opposition brief kept saying, oh, this only becomes a problem, and they ultimately said, if Congress acts and the state of Idaho fails to act, well, how can Congress act and we fail to act? That's the only way it becomes a problem if there's been no delegation. They've admitted implicitly in their briefing that there has been a delegation. And the idea that we have to play defense shows that, in fact, the federal government can change the law and that then we are stuck with it unless we react. So unless you have any further questions for me, I would submit it, Your Honors.
I guess I just have one last question. It's philosophical. I know there's been a lot of heated rhetoric about this case. What you deem as a surrender of sovereignty, the Attorney General's office treats as mere cooperation on a federal level. Philosophically, is it possible for us to work with the government in any way without, in your view, surrendering our sovereignty?
So that's a great question. I actually anticipated you might ask me that philosophical question. What we're talking about here is the federal government likes to seize power. We'll never be able to stop the federal government from seizing power. It just seems to be the nature of humans. What we're talking about is our state ceding power. And there's a difference between those two. And so, yes, we can work with them, but we have to do what we can do to protect jealously our lawmaking authority under our state constitution instead of just what I call was surrendering it. I wish they wouldn't have taken that provision out of the initiative, the sunset clause, for example.
But again, the functional distinction I'm trying to make is this. You're using very heated rhetoric. You're using words like ceding power or surrendering sovereignty. And the Attorney General's office saying we just want to cooperate with the federal government and work and make federalism work for the state. You treat it as an either-or proposition. Isn't it possible to work with the federal government without it being considered a secession of power or a surrender of our sovereignty?
It is, and that's why we've suggested as a remedy what Justice Bakes identified and what the legislature does every year. Let us identify what those rules are in the federal government that we want to accept, which ones we don't want to accept. We don't want to be taking our cooperation, meaning we don't want to be able to have to live by laws that we accept by default.
Isn't that, though, what the people of this state did by passing Proposition 2, decide which laws we wanted to be subject to and which laws we wanted to opt out of?
Well, what they wanted was Medicaid expansion, and the law existed as of the date they adopted the provision that the federal government was going to pay 90%. What we now know is that the Attorney General knows that that can be changed, at least that's his opinion. It's interesting to know that the interveners disagree with that. But we now know that that can be changed, and it could be years before we could get out of it. I don't think the voters knew that that's what they signed up for. Thank you.
Matter is now under advisement. We'll render the decision. Thank you. See you again.